Welcome to this module. In this video, we will look at anti-competitive concerns that may arise in standards development organizations and how to prevent them. Those who followed previous modules may recall that standards are developed collaboratively. Representatives of different stakeholders, often private companies, come together to set a standard. This ensures a broad pool of expertise and that the resulting standards truly reflect market needs. However, situations where competing firms work together can also distort the market or even breach the law. This happens if such collaboration leads to price manipulation, market sharing, or other agreements that harm consumers and artificially restrict competition. Such behavior falls under competition or antitrust law. More precisely, we're talking about collusion, when firms coordinate in ways that have anti-competitive effects. It does not have to be a written contract between the companies. As confirmed by the European Court of Justice, collusion can also result from informal practices, gentlemen's agreements, or any other arrangements that undermine normal competition. Importantly, distorting competition does not need to be the intended object of an agreement. It can also be its effect. In the EU, anti-competitive agreements are prohibited under the Treaty of the Functioning of European Union, the TFEU. Central here is Article 101 sub 1. It prohibits all agreements between undertakings, decisions by associations of undertakings, and concerted practices that have an effect on intra-EU trade, and that have either as their object or as their effect restriction of competition within the European internal market. If a behavior is found to breach this provision, the European Commission and national competition authorities can impose significant fines, and national courts may also award damages against the infringers. The Commission's commitment to fighting collusion and cartelization in the context of a technical cooperation is illustrated by its 2021 investigation into car manufacturers, which resulted in a fine of over 875 million euros. The 5 manufacturers involved have developed technology capable of reducing harmful emissions beyond what was legally required under EU standards. However, they agreed not to use it. What might have been considered legitimate technical cooperation instead became collusive behavior that breached EU law and undermined the EU's objectives under the Green Deal. The European Commission will not hesitate to take action against such illegal arrangements. Under EU law, standards organizations are treated as associations of undertakings because the membership largely consists of private companies. Article 1011 of the Functioning Treaty therefore applies to both European and national standards bodies. If a standards body breaches Article 101, its members can also be held liable. Of course, standards bring many pro-competitive benefits. The European Commission recognizes that some cooperations among competitors are necessary to promote the internal market and may deliver advantages to consumers. For this reason, the Commission has issued horizontal guidelines which clarify when certain types of agreements between competitors can be exempted from Article 101. These guidelines are not binding law, but they're influential and are often used by the courts. The guidelines introduce the safe harbor. If a standardization agreement meets the condition of the safe harbor, Article 101.1 does not apply. The safe harbor has 4 cumulative conditions. The first 2 relate to the rules of a standards organization. Participation in standards development should be unrestricted, and procedures for standards development should be transparent to ensure that all stakeholders are effectively informed about standardization work. Important here to note that the Commission realizes that unrestricted participation is not always possible, and explains that the first condition is still met when there are participatory limitations if there is sufficient competition left between either standards or standards bodies, if limitations on participation are necessary for the standard to be adopted, and if these restrictions are temporary. The other two conditions refer to a standard itself. Under the fourth condition, standards organization should have a clear and balanced intellectual property rights policy that ensures effective access to a standard. If all four conditions of the safe harbor are met, Article 101(1) does not apply. However, non-fulfillment of one or of all of these conditions does not automatically lead to a presumption that the standards agreement restricts competition and thus breaches Article 101(1). In this case, standards organizations need to do a self-assessment whether a standard indeed infringes on Article 101(1), and if so, whether it still can be justified under Clause 3 of this article. Let's look at this provision. 101(3) provides the so-called efficiency defense, which allows agreements that do restrict competition but create efficiencies benefiting consumers. Importantly, to qualify for the 101(3) defense, standards should not impose unnecessary limitations and eliminate competition on substantial part of the products. Because standards typically lead to market efficiencies, it is very likely for them to qualify either for the safe harbor of the horizontal guidelines or for the efficiency defense of Article 101(3). However, some basic antitrust rules always apply in standards organizations. Certain discussions must never take place in standardization meetings or even informally. This is usually spelled out in the antitrust guidelines of each standards organization. Prohibited topics typically include prices, market shares, or ongoing litigation. Even the appearance of such discussion can trigger concerns. Typically, the chair of a technical committee will ensure that these rules are being followed during standards development meetings. In ETSI, these rules are set out in the ETSI Antitrust Guide, which also provides a practical list of do's and don'ts. Every stakeholder should familiarize themselves with this document. To conclude, horizontal cooperation among competitors may result in serious breaches of EU competition law. But in most cases, standardization is pro-competitive and benefits markets and consumers. Standardization agreements are usually protected by the safe harbor of the horizontal guidelines and may also be justified under the efficiency defense. Finally, the antitrust guides of standards organizations provide practical instructions on what behaviors to avoid. Thank you for listening.